Right now, not at work, not clocked in, your employer may know exactly where you are. Which gas station you stopped at this morning, which doctor's office you walked into, how long you stayed, which neighborhood you drove through on Saturday night. And in most states in this country, that is completely legal. Not a gray area, not a loophole. Legal. There's one thing they're counting on, though, that you never find out where that line actually is. The exact point where their right to track you ends and yours to disappear begins. That's what this video is about, and by the end of it, you'll know something most American workers never figure out until it's already too late. Picture this. You just started a new job. Good company, decent pay. On your first day, HR hands you a phone. This is your work phone. Keep it on you. We need to be able to reach you. You sign a couple of papers and a stack of onboarding documents. Nobody walks you through what you're signing. You're new. You don't want to make it weird. You sign. That stack? Somewhere in there, usually buried in the acceptable use policy or the device agreement, is a clause that says the company may monitor the location of this device at any time. At any time. Not during work hours. Not when you're on the clock. Anytime. You took that phone home. You took it to your kid's soccer game. You took it to your doctor. You took it to your mom's house for Thanksgiving. And the whole time, depending on your state and your employer, there may have been a dot on a map moving with you. Now here's the part most people never stop to ask. Is any of this actually legal? And if it is, where exactly does it stop? Here's the uncomfortable answer. Yes. In most states, it's completely legal. And the reason comes down to one principle that American courts have upheld over and over. If the device belongs to your employer, they have the right to know where it is. There is no federal law in the United States that specifically prohibits employers from tracking the GPS location of their employees. None. The closest thing we have is the Electronic Communications Privacy Act, the ECPA, passed in 1968 and updated in 1986. It was written to protect people from having their phone calls intercepted. GPS tracking of a work phone in 2026 wasn't exactly what Congress had in mind. So what fills that gap? Nothing. Or almost nothing. The legal doctrine that governs most of these situations is simple. No expectation of privacy on employer property. Courts have ruled, repeatedly, in most jurisdictions, that when you use a company-owned device, phone, laptop, vehicle, you are generally using it with the understanding that the company may monitor it. That understanding doesn't clock out when you do. And here's what makes this even harder to fight. Most employees signed away any objection to this monitoring before they ever showed up for their first day of work. It was in that stack of papers, on page 7. In the paragraph, nobody reads. Now, the ECPA does have teeth in one specific area. If your employer tries to intercept your actual communications, read your texts in real time, listen to your calls, that's a different legal conversation. But watching a dot move on a map, passive location tracking, the law at the federal level has almost nothing to say about that. Which means the fight, the few protections that do exist, happens at the state level. And what some states have done, and what most states have refused to do, is one of the most revealing things about how much American law actually values worker privacy. In 2015, a woman named Myrna Arias was working as a regional sales executive for a wire transfer company called Intermex, based in Bakersfield, California. Her job was to travel across Central California, visiting bodegas, Hispanic-owned businesses, convincing them to install Intermex machines. A lot of driving, a lot of time on the road. 2 months into the job, Intermex told Arias and her coworkers they needed to download an app called Zora onto their work phones. The app had a GPS function. It tracked their location continuously. Fine. She understood that. She was in sales, out in the field. Tracking during work hours made sense. But then she asked her supervisor a direct question. "Will you be monitoring my location when I'm off the clock? On weekends?" His answer was yes. And then he made it worse. He told her, almost casually, that he already knew how fast she was driving on any given day, that he could see her routes, her stops, how long she spent at each location. Arias compared it to wearing an ankle bracelet. She deleted the app. A few weeks later, she was fired. She sued Intermex for invasion of privacy, wrongful termination, and unfair business practices. She asked for $500,000 in damages. The case settled out of court for an undisclosed amount. Here's what that case actually proved, and what it left completely unanswered. It proved that courts were willing to look at this seriously, that tracking someone 24 hours a day, including off hours, could create legal exposure for an employer. But it didn't establish a clear rule. It didn't set a precedent that every court has to follow. It settled, which means the legal question stayed open. And in the decades since that case, the technology got faster, cheaper, and infinitely more precise. What Myrna Arias was dealing with in 2015 was one app on one phone at one company. What we're going to show you next is what that looks like at scale across millions of American workers right now. You just heard about a woman who got fired for turning off a tracker, and that was 2015. What's happening right now to workers in delivery, construction, healthcare, remote jobs is on a completely different level. If you don't want to miss what comes next, subscribe to LawDrop right now. Hit the like button. It tells the algorithm this information matters. And turn on the notification bell so you never miss a video. Because the next thing we're going to show you doesn't just affect one woman in California, it affects you. Let's talk about scale. According to a 2025 survey by ExpressVPN of 1,500 employers and 1,500 employees across the United States, 74% of American employers are now using online tracking tools to monitor their workers' activities. 74%. And only 22% of employees know they're being monitored. Let that sink in for a second. 3 out of 4 employers are tracking something, and 3 out of 4 workers have no idea it's happening. Now, not all of that is GPS. Some of it is screen monitoring, web browsing logs, keystroke tracking. But when researchers looked specifically at GPS location tracking, they found it in 34% of the most commonly used employee monitoring tools on the market, a number that nearly doubled since 2021. And the workers most exposed? Not the ones sitting at a desk. Delivery drivers, construction workers, home health aides, field technicians, anyone whose job takes them outside a building and whose employer gave them a phone or a vehicle to do it. Amazon is the most documented example. Delivery drivers reported GPS tracking so granular that the system flagged every stop longer than a few seconds, every bathroom break, every moment the van wasn't moving. Managers received automated alerts. Drivers described feeling like every minute of their day was being scored. And Amazon's drivers aren't even Amazon employees. They're classified as independent contractors working for third-party delivery partners, which raises a legal question most of them never thought to ask. Because here's the thing about being classified as a contractor. Most of the worker protections that already exist in this area, limited as they are, don't apply to you. You're not an employee, you're a vendor, and vendors have almost no privacy rights when it comes to the platform that's paying them. But even for full employees, W-2 workers, salaried staff, people with HR departments and benefits packages, the tracking doesn't stop when the workday ends. And the places where it shows up, the scenarios that have been documented and reported, are going to make you rethink every time you've taken a work phone somewhere personal. Here's a scenario that was documented in press reports, and it didn't happen at a warehouse or a delivery company. It happened in a school district. Teachers in at least 3 states received laptops and tablets from their districts for remote instruction. Standard practice during the pandemic. Keep the device, use it for class, bring it back at the end of the year. What teachers didn't know, what nobody told them, was that the location tracking built into those devices stayed active. Through winter break, through summer vacation, through medical leave. Some of them only found out when location data showed up in their performance evaluations. Where you were on a Tuesday afternoon in July, how long you stayed at a particular address, whether you were in the district or out of state. All of it logged, all of it stored, all of it potentially usable. And this isn't a school district problem. Civil liberties organizations have documented similar situations with construction workers in southern states. Workers who were given company trucks as part of their compensation, the kind of benefit that feels like a perk. Take the truck home, use it on weekends, it's yours. Except it wasn't. Not really. Because the GPS tracker in that truck was logging every address they visited on Saturday, every location they stopped at on Sunday morning, every place they went that had nothing to do with work, and everything to do with their private life. Now, is any of this illegal? In most states, no. If the device belongs to the employer can generally track it. The law doesn't require them to turn the tracker off at 5 p.m. It doesn't require them to pause it on weekends. It doesn't require them to suspend it when you're on FMLA leave. Depending on your state, there may be no rule about any of this at all. But there is one distinction, one line in the law that changes everything. And it's not about when you're tracked. It's about what they put the tracker on. Because the moment that GPS moves from a company-owned device to something that belongs to you personally, the legal landscape shifts completely. Let's look at the map. 47 states have no law requiring employers to notify workers before tracking their location electronically. Zero notice, zero disclosure. They can start tracking on day 1 or day 100, and they are not legally required to tell you. 3 states have drawn a different line: Connecticut, New York, Delaware. Connecticut was first. Under its Electronic Monitoring Act, employers must provide written notice to employees before any electronic monitoring begins, including GPS tracking. They also have to post that notice in a visible location in the workplace. And there are explicit prohibitions: no monitoring in bathrooms, no monitoring in locker rooms, no monitoring in break areas. New York followed in 2022. Any private employer with 2 or more employees must notify workers of electronic monitoring in writing at the time of hiring and get a signed acknowledgement. Penalties start at $500 for the first violation and go up to $3,000 for repeat offenses. The state attorney general enforces it. Delaware has a similar requirement: notice before monitoring begins, with the option of either a one-time written disclosure or a daily electronic reminder each time an employee logs into company systems. Now, here's the part that matters most, and that most people miss when they hear about these laws. Notice is not prohibition. Connecticut, New York, and Delaware didn't ban GPS tracking. They didn't limit it to work hours. They didn't say employers can't watch you on weekends. They said you have to tell workers you're doing it. That's it. You get a piece of paper that says, "We may monitor your location at any time." You sign it. And then everything that happens after that, every weekend logged, every medical appointment recorded, every Saturday night route stored, is still completely legal. 47 other states don't even require the piece of paper. So what happens in those 47 states if you think your employer has crossed a line? What if the tracking isn't on a company device? What if they put it on something that belongs to you? Because that's a completely different conversation, and in some states, it's a criminal one. This is where the law actually has something clear to say. If your employer installs a GPS tracker on a vehicle you own, your personal car, your personal truck, without your consent, that can be illegal in many states. California and Texas have explicit prohibitions, and depending on your state, similar protections may apply under privacy or anti-stalking laws. California makes it explicit. Under California Penal Code Section 637.7, it is a crime to use an electronic tracking device to determine the location of a person without their consent. If the vehicle belongs to you, not the company, your employer cannot put a tracker on it. Texas has a similar prohibition on tracking devices placed on vehicles belonging to another person without consent. This matters because the line between company property and personal property isn't always obvious, and some employers have deliberately tried to blur it. There are documented cases of gig workers, drivers for delivery platforms, caregivers placed by staffing agencies, being required to install tracking apps on their personal phones as a condition of getting work. Not a company phone, their own phone, the one they own, pay for, and carry everywhere. When that happens, the legal analysis changes. Courts have been more skeptical of employers claiming unlimited access to data from personal devices. In some states, requiring an employee to install tracking software on a personal phone and then monitoring their location 24 hours a day through that app can expose the employer to invasion of privacy claims. Can, not will, depending on your state. If you're in this situation right now, if you have a work app on your personal phone and you're not sure what it's collecting, here's what you can actually do. First, check your phone's location permissions. On both iPhone and Android, you can see exactly which apps have access to your location and whether that access is set to always, while using, or never. A work app set to always may be tracking your location whether you're working or not. Check with your employer about what data is actually being collected. Second, read your employment contract. Look for words like monitoring, location, device, and tracking. If those words appear in the context of personal devices, you sign something that affects your rights. Third, if you're in Connecticut, New York, or Delaware, and your employer never gave you written notice of electronic monitoring, that's a violation. Document it. Contact your state's labor department or an employment attorney. And if you're in one of the other 47 states, knowing your state's specific laws and knowing exactly what device your employer is monitoring is the difference between having a legal claim and having nothing. Now, none of this is legal advice. Laws in this area vary significantly by state, they change, and your specific situation depends on details that only a licensed employment attorney can evaluate. What we're giving you here is a map, where the lines are drawn, what questions to ask, and what to look for. The rest, if you think something illegal is happening to you, needs a professional. But here's the piece that almost nobody thinks about. Even in states where all of this tracking is perfectly legal, there's something your employer is doing with that data that the law has almost nothing to say about. And it may be the most important part of this entire conversation. Here's the thing nobody tells you. Even in the states with the strongest protections, Connecticut, New York, Delaware, even where your employer is required to give you written notice before they start tracking you, there is no law telling them what to do with the data after they collect it. No federal law limits how long an employer can store your GPS location history. No federal law says who inside the company can access it. No federal law says whether they can share it with a third party, a benefits administrator, an insurance company, a background check firm. Some states, like California, under the California Privacy Rights Act, have their own data privacy laws that may impose additional limits on retention and sharing. But for most American workers, in most states, there are no rules. They know where you were last Tuesday at 11 a.m. They know you left work early on a Wednesday in March. They know you drove past a medical clinic on a Thursday morning and sat in the parking lot for 40 minutes. They don't have to delete that, ever. And here's where it gets used, the part that has ended careers, cost people promotions, and showed up in wrongful termination cases that never made the headlines. GPS data collected months or years ago gets pulled out when there's a dispute. When a worker files a wage theft complaint and suddenly the company has a log showing they left the job site early. When someone applies for an internal promotion and their movement history suggests they interviewed somewhere else. When a disability accommodation request gets quietly denied because the data shows the employee was active during the hours they claimed to be impaired. None of that is hypothetical. Employment attorneys have reported these patterns in litigation. And the most chilling part, the thing that closes this whole picture, is that this data isn't just sitting in your employer's system. In many cases, it lives with a third-party monitoring vendor, a software company your employer pays a subscription to, a company you have no direct relationship with, no legal claim against, and no right to access. Your commute, your errands, your Saturday, your doctor's appointment, sitting on a server somewhere, owned by a company whose name isn't on your paycheck. In most states, that is completely legal. So what do you do with all of this? You use it. You read what you sign. You check your permissions. You know which state you're in. You ask the question before you take the phone home. Because the law, in most states, is not going to protect you automatically. It's not built to. The only protection you have is knowing exactly where the lines are. And now you do. Think about someone you know who carries a work phone. They don't know any of this. Share this video. That's how this information travels. Hit like, subscribe to Law Drop, and ring the bell. And drop the word tracked in the comments if any of this surprised you. Next, we're going to show you what your car dealership hid in the contract you signed. 3 fees, possibly illegal, and they were counting on you not reading past page 2. Don't miss it.